Judge, thank you so much for doing this. I think your voice in this conversation is really important to add some clarity about why the jail is the way it is and how the court system has played a part into it. I'm going to throw out some numbers that I got from the county clerk's office, and I'd like to get your response to them if that's okay.
Sure.
As of August 21st of this year, according to the county clerk's office, there were 11,000 indicted defendants awaiting trial. 12,000 unindicted defendants awaiting to be indicted, and then a grand total of 23,000. That's about 5,000. That's about a 5,000 increase as of December. In your mind, what's causing this backlog in your mind?
Well, part of it is, from a trial perspective, is the unique aspect of the trial of criminal cases. And what I mean by that is that 90 to 95% of all criminal cases will be resolved by a plea. And so if I can give you an example, when I call a 40-person trial calendar, about 20 to 25 of those people are going to enter pleas on some point in time on the continuum. Then you're going to have 5 folks that, or thereabouts, that have mental health challenges. So they either need an evaluation, they're pending an evaluation, or we need the results of the evaluations for the parties to be able to do something. Then you got about 5 folks that you can't do anything because of science. And then what I mean by that is because there's sexual assault kits or science that needs to be tested by other agencies. So their cases aren't in a position to be tried. And then you got 5 folks that are just going to say, I want a trial, and that's their constitutional right to go to trial. So if you look at the trial of a criminal case, a homicide, it takes 5 to 10 days to try those cases. And then on the average, a regular felony is going to take probably 3 to 5 days to try. So I can try 4 to 6 cases in a month's time. And so if you think about the other 2 categories of mental health and the science cases that are still outstanding testing, then coupled with the fact that I get new cases on top of that, I have to continually kind of touch those cases in order for them to be able to move. So that's part of the unique challenge of the trial of criminal cases. So and then you get new cases, and that adds to our current situation.
So the competency issue, the science, which it sounds like you're saying just lab results from GBI or
Yes.
the agency. What was the pleadings that take time? I was trying to go through the list of your reasons for. I want to make sure that.
Yeah, the people end up taking pleas.
Okay.
I mean, and you're going to have 20 to 20. I'm just making a representative sample of 40 folks. So 20 to 25 are going to plead somewhere around, or take a negotiated or non-negotiated plea sometime on the continuum, based on 90 to 95% of all criminal cases get resolved by plea. But then you've got science, then you've got the folks that have mental health concerns, and then you have people that want trial. So that's your last category.
Okay.
So those particular categories, and then I have to touch the people that have competency issues and follow up on those, and then I also have to recalendar the people that are still outstanding lab results, because the prosecution makes decisions on whether or not to continue to prosecute that case, and if I'm a defense attorney, I have to be able to see whether or not that particular test result may provide my client with some type of defense, and we can't resolve those cases until those things are at least put to rest.
How does this impact the jail population, knowing all the factors that you just explained and how the backlog has increased? How does this impact the jail?
Okay, well, if you look at it, it's a collaborative situation, but for all of us as justice partners. But if you look at the population of Fulton County is the biggest county in the state. We are the seat of government. We have almost 1 million people within Fulton County. We have 15 municipalities, including the city of Atlanta, which has nearly 500,000 people in and of itself. So we're a 365, 24/7 criminal justice entity. And then we've got a jail that was built in 1989 to house 1,100 people, that we have doubled the amount of folks in there, just due to those factors I just discussed. And then overcrowding is a national issue, Andy. We're not the only I would say, county or city that has to deal with the issue of overcrowding. And then we got, if you overlay on top of that, the effects of COVID and the fact that those particular people that were arrested during that particular time period. And then, as I mentioned, the unindicted cases that you brought up. We as the court can't do anything until those particular cases are in fact indicted. And two of the factors we just discussed about, in particular, science, outstanding, as well as the challenges with mental health defendants. Those are two things that Madam District Attorney Ms. Willis has to contend with to make a determination on whether or not to indict somebody and how to proceed and prosecute on those cases. So those two things really make a big difference on the ability for us to tackle those particular that particular jail population.
I found that the sheriff provided me some stats himself that I thought were very compelling. There were, as of August, there were 690 individuals booked in jail for at least 1 year or longer waiting for trial. 3 years or longer, 142 inmates, and 19 waiting 5 years or longer. The DA says for those 19 waiting 5 years or longer, there were competency issues. They were in and out of mental health facilities trying to get them competent enough to go to trial. There was a gentleman I found waiting 13 years for trial. Again, he had competency issues. Should it take 5, 10, 13 years to determine whether someone's competent enough to go to trial?
Well, what I tell you to begin with, I can't comment individually on any of those cases because of the requirements of the judicial canons of ethics. But what I can say that each particular case is unique and has its own set of circumstances and facts. And while it's not acceptable for people to spend those particular lengths of time in jail, our appellate courts review these particular types of cases on their individual basis to determine if that was appropriate. And this is something that we as justice partners are working very hard to identify cases that need some attention for various reasons. But as the things you just mentioned, mental health is a real big concern with, because if you can't get somebody competent, you can't try them. And then there are limited issues as to what you can do with that particular accused in that particular case until those particular issues are resolved. So the prosecution has challenges with those types of matters, and so does the defense, and so does the court.
Yeah, my jaw dropped when I heard 13 years for that one individual, and I know you can't comment specifically on his case, but man, 13 years being in legal limbo, that's got to be really concerning to hear.
Yeah, I mean, it's one of those things you get on an individual basis. You have to kind of, without taking a look at the individual facts of that particular case, that's something that those lawyers as well as the court on appellate review will kind of take a look at to determine if it was constitutionally permissible and proper.
Here's some other jail stats that I got from the county court administration. As of July, there were 1,200 individuals who were detained in the jail waiting for an indictment. According to the county and the DA, 400 to 500, interesting how I can't seem to get accurate numbers, but between 400 and 500 individuals have been waiting more than 90 days, some more than a year. What's your response to those numbers?
It's similar. I mean, I believe that in individual cases and the development by our district attorney, that's her complete and exclusive purview. But a lot of times, investigation and science and people's mental health all roll into those particular types of decisions of whether or not they're in a position to indict. So without knowing more specifically about those particular matters, but and I think you have to kind of look at that in terms of whether or not we're able to go forward on those criminal cases. Is, are they in a position to be charged or to be prosecuted or presented to a grand jury?
Do these individuals, those 1,200 that I mentioned, do they even come before you before they're indicted at all?
Depending upon whether or not they are bond eligible. Mm-hmm. I mean, because the charge of a criminal case, determines whether or not and how the case proceeds in the criminal justice system. So those people have more than likely been charged and are brought before a magistrate. They've had a bond determination, and for some reason or another, that's where the case kind of stalls because of, well, we need ballistics, or we need the sexual assault kit, or we need some DNA, or some other type of thing that's missing. And as we talked about a little earlier, Andy, that's kind of the challenge that our system sees in resolving those kind of cases and getting them, I would say faster in terms of our ability to take care of them.
I'd like to get your response to what Fulton County Chairman Ron Pence told me just last week in a sit-down interview. And I asked them, I said, what's the contributing factor for you? Why do you think the jail is backlogged the way it is? And this is what he said, quote, he said, some work, talking about judges, some work, some do not. Some come to work at 10 a.m. in the morning, go to lunch at noon, play golf. We monitor this. The judges who are working come to my office and tell me which ones are working and which ones are not working. The reason is they can do what they choose to do because the public doesn't care. What's your response to what he said?
Well, I would disagree, because this particular issue of overcrowding in the jail is a collaborative effort. And of course, we stand ready to work with our partners. And just as a review, Andy, on a regular basis, we meet monthly with our justice partners, the DA, the PD, as well as the representatives from Fulton County government to monitor those particular numbers. We've added 4 senior judges to help out in the trial of criminal cases.
What's the timeline for that? Like when you started adding them?
We started adding those, I want to say about 6 months ago.
Okay.
Adding those judges. And then we've collaborated with our state court partners, and they have taken some of our civil cases so that we can concentrate on the trial of criminal cases. And then I know our judges have prioritized the trial of those people who are in jail. And in fact, we've reduced since December of 21 the COVID backlog by 57% of those people who are in custody. So I know we're working really, really hard. And then I'd like to be able to tell you that within a couple of weeks we're going to vote on establishing a competency court, so that a particularized judge can be responsible for those types of cases I told you about, that we have some challenges with people with mental health concerns.
So a judge, you're looking to have one judge handle all the competency issues? Is that what you're saying?
Well, the competency cases, yes.
Competency cases,
yeah.
okay.
And this judge would track them from the time that they hit the jail and would come up on a calendar. So instead of my dealing with that particular person, you have an individual judge that follows that particular case so that it doesn't drop through the cracks. Or we can, as I mentioned, with criminal cases in particular, you have to touch them on a regular basis for them to move.
It's like a state law, right? Like they have to be like every 6 months or a year or something like that?
Well, yeah, it depends on your status in terms of whether or not you've been deemed competent, but you do come up for review pursuant to state law.
That's okay,
yes.
Yeah.
And that's one of the things that an individual judge would make sure that occurs. In addition to, is there any other things that can be done to help that person become competent, or for the state or the defense to resolve that case? But what it does is it just kind of makes sure that those things stay to the forefront so they can be resolved in the most expeditious time and manner possible.
So that's a request that you've made to the commission asking to fund this specific type of office or judge?
Well, what we've done is, as a whole, there are some other places in the state, like Savannah has a competency court, through partnerships with our district attorney, our public defender, and with our justice partners across the street. We have decided that this would be an important thing for us to kind of keep track of in terms of our being able to better maintain these kind of cases and give them the attention they deserve, because they need it. They need to be processed in a timely manner. But sometimes it's just the unique nature of issues involving mental health and competency. At any point in time, Andy, we deal with 40% of the population has undiagnosed mental health challenges, and it is a national issue and a national concern. So that it is not inconceivable that people that come cross purposes with the justice system have these kind of conditions that need to be identified and determine whether or not it will factor the prosecution or defense of that particular case.
So a competency court, that's one potential solution to help. What else?
Yes. We're very much. Let me start over again with that one. Okay. In terms of what else, we work well with our justice partners across the way, and they have funded us, and they have given us the resources and tools that we need. But we could always use more particular participants to deal with this criminal justice.
More judges?
More judges, more public defenders, and more prosecutors, because all of us play a part in resolving and the trial of criminal cases. And I know that all of us work very, very hard, even though there's natural friction between the district attorney, the public defender, the conflict defender, and the court. That's natural. But we as professionals and as attorneys understand our roles and responsibilities, but it does require still collaboration to make justice work. And I know that every 2 weeks our public defender as well as our prosecutors get together and they try and resolve cases that are pending in the Fulton County Jail. So I know we're working very, very hard, but we stand ready, and we'll continue to stand ready to work with our partners across the street in government.
The DA believes that when I asked her what potential solutions there are to address this, she said more judges, more prosecutors, and the GBI needs more funding for its crime lab.
I don't disagree with any of those. In fact, she just got a $2.5 million grant to help in the processing of some over 4,000 sexual assault kits that need to be tested. And I mean, that's just one example of how important science plays a part in the determination of prosecution of criminal cases as well as the resolution of those criminal cases, as I mentioned earlier. If I'm a defendant and that science will exonerate me, or at least give me a better understanding of where I stand with that case, there's nothing I can do until I get that data point, and that's why that science is so important. And then it's just our ability to try these cases is very dependent upon that particular issue.
There isn't a courtroom in this building that I haven't been to where at least at some point I see a defendant show up for a status hearing and doesn't have a public defender. How big of a problem is the public defenders, the lack thereof, to this issue?
Well, I really can't speak to the public defender and their numbers, but having worked as a defense attorney, the whole public defender system is just very important, because if you don't have public defenders, criminal accused, it affects their ability to have adequate representation.
Do you think there are enough of them in this county or in this state?
I'd like to see more. Because you're limited by the number of attorneys that you have, and especially now with a number of multi-defendant cases, we need more defense attorneys and conflict defenders to help out in the trial of these particular cases, represent people in the trial of these cases. So yes.
When I'm going to talk a little bit more about one last thing that Chairman Pitts mentioned at that quote that I read to you. The reason is they can do what they choose to do because the public doesn't care. So I was like, what do you mean the public doesn't care? And he says the public doesn't give a damn. It's the public's fault for re-electing them. He's talking about judges he believes aren't doing their fair share of work. What's your response to him putting the blame on the public for electing the judges that aren't allegedly doing their job?
Well, that's his opinion, but as I mentioned earlier, I mean, we all are working collaboratively, and I think it's a group responsibility for all of us to continue to work as hard as we can, to deal with the overcrowding issues and to work hard so that criminal cases get the constitutional requirement that they are supposed to get. So I think that we're working as hard as we can as judges. As I mentioned, you know, there are unique challenges with the trial of criminal cases in terms of just scheduling, and then our ability, and then the reality and pragmatism of moving those cases, given some of the issues we talked about in terms of the availability of counsel, the availability of testing and lab results, mental health struggles, and then the fact that it's time over people, because I can only try so many cases per month. And I know that all of our judges are working very hard, as well as our prosecutors and defense attorneys and conflict defenders and private counsel, so to resolve the trial of criminal cases.
Do you think the county needs a new jail?
Yes. Yeah. We need a new jail. I mean, it's we have 1,100. It was built, like I said, in 1989 to house 1,100 people, and due to population changes and just we're at double that particular capacity. So, you know, I know our sheriff has petitioned the commission for the building of a new jail, and time will tell whether or not that occurs. But it would certainly be one of those pieces that would tend to resolve some of our overcrowding and issues.
The reason why I asked that, because I asked Chairman Pitts, and he says, I don't think we need a new jail, because as soon as it opens, we're still going to have this backlog issue, and we're going to have the same issue. So that's why I asked. The DA believes the same thing as you. We need a new jail. But what's your thoughts on him assuming that the backlog will stay the same even if we get a new jail, and we'll have the same reoccurring issue of overcrowding?
Well, I mean, but it's a multifaceted issue, Andy. I think that we need to continue to work toward. I mean, population, just crime as a whole. You know, that we're a 365, 7-day-a-week operation in terms of justice, and that if we use these particular tools and work collaboratively, we should be able to process cases timely. I can't speak about the jail population because, you know, that would be speculative in terms of just who's going to be arrested for criminal offenses and the like. So I don't know if there's a correlation between what he said about it's just going to fill up again. We're going to try and use all our tools to make sure that those particular people who are in custody get their cases resolved as quickly as possible. That doesn't connect with the jail population in and of itself. So,
last December, you signed an order suspending defendants' ability to request the speedy trial. Tell me a little bit more about why you did that, and knowing what the numbers are today, do you regret that decision?
Well, the order you're talking about is for the constitutional and not constitutional. I'm sorry, the statutory speedy trial demand. Our Supreme Court of Georgia authorized us to suspend those particular cases during the pandemic. So that particular order that I signed in January is to give us a little bit of time to kind of develop some of the tools that I talked with you about, and to resolve and or better resolve criminal cases. That order has sunsetted. So as of this past July.
Yeah.
So,
do you think that suspension impacted the backlog during that time?
I would say so, because we were not able to try as many cases during the pandemic, given the health concerns. So, yeah, it had an effect. But now that we are beyond that, you know, it is with all of our responsibility to work as hard as we can. That was just a unique time and period, I think, in Georgia history and in our criminal justice system, where that particular, the pandemic itself and COVID affected our ability to try criminal cases. So, and to overburden the system, that was just one stopgap provision. But, you know, it's been lifted, and we are trying very, very hard to process criminal cases more efficiently.
The county has an operational report that they release, I guess, every meeting or every month. I don't know how
I think it's done on a monthly basis.
Month to month. And I've never seen this before, but when I asked Chairman Pitts, I was like, why do you put the blame on the judges? Like, isn't this multifaceted? And he pointed me specifically to this graph where it shows how many detainees by Superior Court judge that are assigned to them. You have the lowest number, and then there are some of your colleagues that have high numbers. Do you think this is a fair depiction of the issue impacting the jail and the number of detainees assigned? Do you think this is a fair comparison?
No, it's not.
Tell me about that.
Well, for the reasons that we talked about earlier. I mean, each individual judge, cannot control necessarily who makes up their docket. So if I have a bunch of people who are in custody waiting trial or pending trial, and they have mental health, and they have science, and they have attorney issues, I can't try those cases. So that's kind of an unfair statement to say, well, you have these particular people in jail. The judges don't control that particular issue. That's just meted out by the individual circumstances of this case, because I can tell you that all of my colleagues are trying very hard to try the cases that are in custody, but you're hamstringed a lot of times by some of the issues that we talked about already: science, ability to obtain counsel, and as well as the just scheduling, and because I can only try one particular case at one time and resolve those. Mm-hmm. So I don't think his comment's fair at all.
Knowing that the county actually produces this document, are you guys having conversations going, wait, before you put this in this report, here's some perspective you need to know, or hey guys, this isn't fair?
We've had some conversations with the county about that, mm-hmm. With our justice partners, and we've asked them to take into account the factors that you and I have just discussed. But they're entitled to publish those numbers. But one of the things that is that they have to kind of always realize is that we are an independent branch of government, and that we have the ability to process these cases in a constitutionally responsible manner. It seems like that there's a blame that's being put on the judges for not trying these particular cases, but it is not a one person blame. If I can't move a case because the DA is not in a position to indict it, if I can't move a case because I don't have the science behind to make sure lab results, if I don't have the ability to have another lawyer because we have a decrement of public defenders or C3 attorneys, then that impacts my ability to try that particular case that may be in custody. So when our chairman talks about those issues and that publishes that particular graph, it's not representative of all of the issues that kind of make up that. But just like overcrowding didn't happen overnight, the things that we're doing today really are trying to address that particular issue.
What are we not talking about that you think is important to this conversation?
I think that we've talked about everything. I really have, in terms of everything. I mean, but we have our challenges. But I do believe that this is a collaborative solution. This is a collaborative task that we need to continue to work very hard at, so that the jail numbers can go down and people can be processed in a constitutionally responsible manner.
A year from now, what do you think the numbers will be, or what do you think the conversation will be?
The conversation will be that these numbers will continue to decrease because of all of our work, and all of us have a responsibility in our respective areas to try and work collaboratively to put these cases in the best posture to resolve. It makes no difference to any of us if you want to have a trial or you don't want to have a trial. We're constitutionally mandated to give you time and opportunity to have your case heard, either before a judge or jury, and that's what we're going to continue to do.
There seems to be fewer and fewer trials. Like if you wanted the trial, you almost suffer more because it takes so long to get to trial. Is that a fair assessment?
No, I don't think it is. I think that based on the individual circumstances of any case, will dictate how fast your case may be able to go to trial. And and certainly you want to make sure that you're in the best position, no matter who you are, the state, the public defender, or the court, to provide the best possible representation for the entity that you have. The court is the charged with responsibility of giving you a trial, but I can't give you a trial if we're not ready to go. It would be one thing if the state was standing up and saying, "Hey, judge, we're ready to go. We're ready. We've gotten everything," and the defense is doing the same, and then the court's not being responsive. That is not the case. So, if your case is ready to go, we'll be able to provide you a trial. But we're limited by some of the things we talked about, Andy, in terms of just the availability of counsel, and the fact that felony cases take much longer to try. They're more complicated. They require more development than, for example, a misdemeanor that may take only a day or so to try. So that's part of the challenge with criminal cases is you can only try so many at one time. And we strive to be efficient, but it's just the reality of in a month's time, I can try 4 to 6 cases or thereabouts, and there are 15 of us that do criminal cases. So it's a management issue, and we really have to. And as I mentioned earlier, the trial of criminal cases requires button seat time, and you have to touch that case in order for it to move. Yeah. So that's our challenge. But a year from now, I believe those numbers will be down.
And if there's anyone that knows how to try multiple people at the same time, I think it might be you. Last question, a criminal defense attorney once told me he compares the Fulton County Jail to Guantanamo Bay, Gitmo, because just like at Gitmo, there are individuals who have never been officially charged for a crime, waiting a significant amount of time. There are people in Fulton County's jail that have been waiting a year or longer to be indicted, officially charged with the crime. When you hear that comparison, what goes through your mind?
I really don't have a comment on that, because as I mentioned earlier, each individual case has its own set of circumstances that you kind of can't paint all the cases with the same brush. So for the reasons that we talked about earlier, in terms of just personnel, science, and mental health challenges and other things that go into whether or not that case can be brought forward. I think for a number of people, they look at, well, the person's in jail. Well, that person has been to see a magistrate, has had a bond determination, and if I know from my perspective, if I have not given you a bond, it is really incumbent upon me to try your cases expeditiously as possible. So I share a lot of frustration when I know from my perspective, if I know from my perspective, if I have not given you a bond, it is really incumbent upon me to try your cases expeditiously as possible. So I share a lot of frustration when I know from my perspective, if I know from my perspective, if I have not given you a bond, it is really incumbent upon me to try your cases expeditiously as possible. So I share a lot of frustration when I know from my perspective, if I know from my perspective, if I have not given you a bond, it is really incumbent upon me to try your cases expeditiously as possible. So I share a lot of frustration when I know from my perspective, if I know from my perspective, if I have not given you a bond, it is really incumbent upon me to try your cases expeditiously as possible. So I share a lot of frustration when I know from my perspective, if I know from my perspective, if I have not given you a bond, it is really incumbent upon me to try your cases expeditiously as possible. So I I have not given you a bond. It is really incumbent upon me to try your case as expeditiously as possible. So I share a lot of frustration when I can't get persons to come before, like defense attorneys to come before me because they've got other cases. I mean, that's just a reality. I'm not laying blame on anybody. Or I can't get the science that the GBI may have or another entity. It's not ready or hasn't been. It's in the queue to be tested. Or I have mental health challenges that I got to deal with from a defendant whose counsel has raised, well, the basic issue of competency, because if you're not competent, you can't go to trial. But I have to continually touch and manage those cases in order for them to resolve. But that's my responsibility. I mean, is to make sure we keep.
There are people in Fulton County Jail that have been waiting a year or longer to be indicted, officially charged with the crime. When you hear that comparison, what goes through your mind?
I really don't have don't really have a comment on that because, as I mentioned earlier, each individual case has its own set of circumstances that you kind of can't paint all the cases with the same brush. So for the reasons that we talked about earlier, in terms of just personnel, science, and mental health challenges and other things that go into whether or not that case can be brought forward. I think for a number of people, they look at, well, the person's in jail. Well, that person has been to see a magistrate, has had a bond determination, and if I know from my perspective, if I have not given you a bond. It is really incumbent upon me to try your case as expeditiously as possible. So I share a lot of frustration when I can't get persons to come before, like defense attorneys to come before me because they've got other cases. I mean, that's just a reality. I'm not laying blame on anybody. Or I can't get the science that the GBI may have or another entity. It's not ready or hasn't been. It's in the queue to be tested. Or I have mental health challenges that I got to deal with from a defendant whose counsel has raised, well, the basic issue of competency, because if you're not competent, you can't go to trial. But I have to continually touch and manage those cases in order for them to resolve. But that's my responsibility. I mean, is to make sure that we keep attention on those particular cases, and I reset and I status a number of cases multiple times before they may be ready to go to trial. And I don't mind doing that, but I think that's my responsibility.